All right, ma'am.
May it please the court, my name is Rebecca Creed. I'm from the Jacksonville firm of Creed and Gowdy. We represent the appellant, former husband, Dr. David. The former husband's entitled to reversal of the successor judge's final order on appellate remand. This order was entered based simply upon the successor judge's review of a cold record, the transcript of a proceeding that he did not preside over, his interpretation of the prior judge's findings, without hearing additional evidence or any evidence related to the equitable distribution of the party's assets. This court, in its first opinion, remanded to the trial court to reconsider the distribution of the party's marital credit card debt, to remove the special equity, to remove the life insurance requirement, but also to revisit the entire equitable distribution scheme, in this case, to determine what's a fair and just distribution of assets and liabilities.
Well, but we went on to say, and I agree that language probably is there, but we said to review the equitable distribution scheme in light of this opinion. Which to me, and I wasn't on the panel, not that that would make a difference, but I mean, to me, that suggests that, follow the directions that we've given you, and if that causes some other change, then you can look at it. But as it turns out, the three changes here, one of them had no impact on equitable distribution. The life insurance didn't affect equitable distribution, so that just disappeared. And the other thing were just purely mathematical calculations.
Your Honor, the language of this court's mandate, the court also cited to the Noah versus Noah case in Vandenberg, and in Noah, the Supreme Court established that it's not enough just to look at one particular asset and to maybe shift that asset from one category to another. In that case, the Supreme Court reversed the District Court of Appeals decision to just shift around assets in an attempt to calculate equitable distribution. Excuse me. And in this case,
well, if you look at the distribution, it's equally split after remand, what the new judge did.
But the new client made out better on remand than before.
Well, maybe yes, maybe no. We don't know that because we were prohibited from introducing any evidence. The problem that we have in this case is that it was a successor judge, and the evaluation under this court's mandate to revisit the entire equitable distribution scheme necessarily involved weighing credibility and evidence and making findings that the successor judge had no ability to make based on this cold record.
But in the first appeal, my memory is that your client raised 10 separate claimed errors, and we affirmed 7 of them. The 3 of them, seem to be readily calculable. Wouldn't it have been error for the judge to go beyond the scope of, wouldn't he have gone beyond the scope of the remand if he revisited, for example, the 6 or 7 items that we had previously affirmed?
If it had been the same trial judge, it would have been a different consideration. Even then, we don't concede that that would have been law of the case based on the language of the court's mandate to revisit the entire equitable distribution scheme in this case to determine what's fair and just. And the problem, again, that we have is that this was a successor judge who relied simply on his reading of a transcript in which he did not preside over, to then make what he perceived to be a split right down the middle. But he did not have the ability to view the parties, to consider their testimony and evidence, to consider that firsthand. He instead just looked to what the original trial judge had done and those original findings of fact. The facts have changed. We were prohibited at every turn from attempting to invoke this right that we had to a trial before a different successor judge, and there's ample Florida case law that establishes that once there is a successor judge to fulfill the requirements of the mandate, it's not enough to just look and compare testimony that was heard before the other judge. This court in the EJ versus Department of Children and Families decision, a successor judge cannot generally make findings or render a final decree, even though the testimony is transcribed at the original trial and preserved. A successor judge who does not hear all the evidence may only enter a verdict of judgment upon a retrial, or if the parties stipulate to a decision on the basis of that record. Here we never stipulated to the successor judge making these reevaluation of findings based on that original record. We asked repeatedly for a new trial, and we were denied that ability.
And did your request for a new trial include things such as alimony?
We asked for a new trial on everything, on the entire equitable distribution under the language of this court's mandate.
I mean, wouldn't that have been problematic? I mean, even if we take a very broad interpretation of that, it said revisit the equitable distribution scheme in light of this opinion. So wouldn't a revisitation of alimony based upon changed circumstances be beyond the scope of the mandate, even under that theory?
No, Your Honor, we don't believe so, because under the statute, and the remedies are all related. And again, in Noah versus Noah, the Supreme Court ruled that it's not enough to just look at one remedy and separate and apart from the other ones. The remedies are part of one overall scheme and must be viewed as a whole rather than independently. And so the entire distribution scheme necessarily includes not only the equitable distribution of assets and liabilities, but also the award of alimony.
But the award of alimony was specifically upheld in the previous case.
The award of alimony.
Isn't your client asking for a second bite at the apple, basically, to go back and revisit everything when that is not what the prior decision of this court held?
To the extent that we believe we were entitled to a second bite at the apple because of the successor judge. It's not to say that we may have stipulated to the trial judge considering certain issues. Certainly the former wife could have argued that certain issues were law of the case, but we never even got that far because the successor judge decided that he was going to review what the original trial judge had done and review a cold record, which is prohibited under Florida law. The successor judge, his actions were not...
Are you saying that if the successor judge had a new trial and still came out with the same distribution scheme he had come out with, it, you wouldn't have an argument?
Probably not, because at that point he would have evaluated the witness's credibility and heard the evidence. We attempted to show the successor judge how the facts would have changed on equitable distribution items, including...
You wanted a different valuation date. You wanted to have a new valuation date. Why would that be necessary?
In light of the time that had passed since the original final judgment, to determine what is fair and just under the circumstances, the trial judge has the ability to determine that evaluation date and is
That was already
charged...
set.
Excuse me?
That was already set, and that was basically the law of the case.
But the facts had changed, and so that's not the law of the case when the facts have changed. And there's, again, the necessary to determine what's fair and just.
As in any situation, facts are going to change. I mean, that's like saying you get divorced 5 years ago, everything's affirmed, but we want to revisit everything 5 years later because now the facts have changed.
But what you have in this case is a mandate from this court directing the trial court to revisit the entire scheme to make sure it's still fair and just in light of this opinion.
And this opinion, in light of after going back and revisiting A, B, and C that we've asked you to do by making these adjustments, take a look at it and see if it's still equitable. In light of this opinion, that's what that means. And the trial judge did go back and look at everything. In fact, I believe if I read correctly, listened to the tape, listened to the CD of the trial, and so heard the testimony, and then reviewed the record, listened to whatever arguments that y'all made, went back and decided that it is equitable, and actually, your client benefited greatly. I show a gain to your client at $51,683.28 on special equity and $33,300 on marital credit card debt.
Your Honor, again, we don't know what the evidence would have shown at a new trial, and to hold that this successor judge is entitled to go back and listen to a CD and to review the transcript at a hearing where he was not that he did not preside over is contrary to Florida law. That is a cold record. A successor judge is not entitled to make findings based on that cold record, no matter whether he listens to the original transcript or trial proceedings or not.
Well, what
He did not have the ability, to view the credibility and weigh the credibility of the witnesses.
Well, let's just say you want to go back and revisit some of this evidence. What on earth is the relevance of the proffer that's submitted to this case, revisiting former husband wanted to present testimony from the former wife's former stepmother, that the former wife's father attempted to kill the former stepmother, the former wife's paramour wanted to testify about an ongoing relationship during the marriage, graphic photographs, testimony that the wife is a drug and alcohol. What possible relevance does any of that have to the issues that were presented on remand?
The other issues, that is a section in the reading from the written proffer, which the trial judge refused to even consider. But the other relevant issues would be the former husband's earning ability, the value of the dental business, the testimony and evidence that the value of the marital home had decreased. The husband in the original judgment was ordered to pay the mortgage payments, and so...
Marital home, the court didn't say an amount that would be given to the former husband or the former wife, just said 50% of the net proceeds. And that was even the original trial judge did that, except giving the special equity, which was then ruled should not happen. And it still is 50% of the net proceeds. So it's not, what new evidence would have changed the value of the home? It's of no consequence.
Your Honor, the original judgment did say 50%, but it also refused to give, the original trial judge did not give the former husband any credit for mortgage payments that were made. To the extent the value of the home is continuing to decrease, how is that a fair and just evaluation based on new evidence at the point in time when this trial judge has been ordered to revisit the entire scheme and to make a fair and just evaluation? Also, it's not entirely clear from the final order on appellate remand that that's what the successor judge did. If you look to that equitable distribution chart that is attached to his final order, it appears that he instead did establish a value for the home and awarded the wife $519,000 of that $800,000 value. So it's not clear that he did exactly what the original trial judge had. He, in fact, used non-marital assets in the valuation, a couple of accounts from the former wife. He used the wrong number.
Wrong chart, but on marital home, it says no value indicated.
On page 120 of the record, which is the final order on appellate remand, it goes through and it does assign a value, and it does include on the pages related to the retirement accounts, which is also page 120. It includes portions of two accounts that were supposed to be under the original final judgment non-marital accounts. So it's not clear that the successor judge did exactly what the original judge had done and just substituted out these amounts. There are mistakes in his findings. His findings are not supported by competent substantial evidence. There is case law. The Dash versus Dash case was a case that arose in this circumstance where there was an appellate opinion and on remand the judge was different. And in that case it was a question as to alimony, and the successor judge attempted just to go back and look to what the prior trial judge had done and the transcript before him. And the third district said, we think it was improper for the new trial judge, who was unacquainted with the earlier testimony, simply to make his determination of a new alimony based on the appellate record. It's not enough, because this court, just like the successor judge, didn't hear the witnesses, didn't evaluate their credibility. And so for the successor judge to come in like this court would and to reweigh the evidence and to make an equitable distribution based on facts that he did not have before him and that he didn't hear in the first instance is error under ample case law that we cite in our initial and reply briefs. Argument of counsel is another element. That's never evidence. So it's not enough to rely just on the cold record. The successor judge's rulings were harmful error. He did not attempt to fairly and justly evaluate the assets and liabilities. Instead, he just relied simply on this cold record and whatever had happened at the first trial. He refused to let the former husband even submit a written proffer of evidence to show what would have changed. And so, to the extent this court is concerned about any delay, the delay has been caused by the former wife, who's objected to the retrial, despite the fact that under the case law of this state, a successor judge is not entitled just to look at what the predecessor did. It's even if the predecessor judge had left notes as to what he intended to find, the courts have held that that's not enough. And instead it is that the successor judge, like this court, can't just reweigh evidence. Instead, it needs the successor trial judge must be in a position to evaluate the witness's credibility, even if it's just a simple matter of going back and revisiting and reconsidering equitable distribution. It's still a matter to weigh the evidence, consider the weight of the evidence, the credibility of the witnesses, and then make a determination as to what's fair and just. I'll reserve the balance of my time.
Thank you, ma'am. Morning.
Good morning, may it please the court. My name is Sean Shepard. I represent the former wife, Loretta David, in this case. I would submit to the court that the successor trial judge in this case went above and beyond what I think would have been acceptable to this court as far as a review of what happened previously. As the court pointed out, Judge DuPont went back and not only looked at the equitable distribution chart that was prepared by Judge Nichols years before, but he also went through a stack of evidence that was feet high, and not only read the transcript of the proceedings, but also listened to the audio of the proceedings of the testimony provided. So I would submit to the court that he went above and beyond in doing an assessment of an entire record here, which was there for his benefit. Not that he was required to do all that, but the fact that he did that, I think, lends some more credibility to the decision here. With regard to the issues on appeal, appellant submits to the court that Judge DuPont failed to follow the express language of the mandate. And submit to the court the express language of the mandate simply required him to revisit the equitable distribution scheme with the qualifier that it be in light of the opinion. It wasn't, the sentence did not end at what is fair and just distribution of assets and liabilities, period. It says in light of this opinion. My client throughout the trial and on appeal now suffered an $84,993 loss to her column as a result of the first appeal in this case 2 years ago. And when we went back before Judge DuPont, we conceded those issues for purposes of trying to get the case completed. There was no contest to those issues from appellant. And what happened was the $80,000 in marital credit card debt that my client was paying for throughout the proceedings, and in fact paid for through this year and serviced through this year. She ended up not getting the benefit of the original ruling, but only got the benefit of being reimbursed for half of that amount. So in addition to having to service that debt the entire time, she also suffered the loss of almost $85,000 to her column. Conceding that issue in an attempt to get the litigation completed as quickly as possible. That was not enough for the appellant in this case. Appellant submits to the court that he's just entitled to an entirely new trial based upon the language of the opinion. I submit to the court that the language of the opinion and the mandate taken in the context of the paragraph that immediately preceded it, where it says the court must reconsider as opposed to reconsider the distribution of the parties' marital credit card debt, required Judge DuPont to do a little more with regard to the credit card debt than he would with the entire equitable distribution plan, that the distinction between the terms reconsider and revisit are of consequence in the court's analysis of what the successor judge was required to do on remand, and that revisiting the equitable distribution scheme simply required him to look at the chart of equitable distribution and determine in light of that $85,000 loss to my client whether she was still being treated fairly with regard to the equitable distribution of assets and debts. As the court pointed out, the issue of alimony was heavily litigated at the trial level. It was appealed as a separate issue on the first appeal that came before this court and affirmed by this court. To allow the appellant now, they're attempting to cite the case law to attempt to intertwine the issues of alimony and equitable distribution to get another bite at the alimony apple would be improper. We've cited in our brief to law of the case and res judicata support for our argument that to allow the appellant at this point to re-argue the issues of alimony that were affirmed on the first appeal, to re-argue the issue of the distribution of the dental practice, which is arguably the largest asset the parties had, would be in contradiction to the court's decision on the first appeal. The dental practice, during the trial proceedings, the dental practice, the parties stipulated to Roger Barong, who's a well-known business evaluator in the area. They had a consent order on a temporary basis to have him appointed. They agreed to both his method of calculating the marital portion and appreciation of that asset. They agreed upon the dates of that appreciation, beginning with the date of the marriage, even though the former wife had worked at the dental practice prior to the marriage. They utilized the date of marriage as the start date. They established a valuation as of that date. They also established a valuation as of the date the parties separated from one another as opposed to the date of the final dissolution, and included valuations at the date of separation and date of dissolution, and included a calculation utilizing the number of months of marriage during that period of time. I would submit to the court that had they used the date of valuation as the date of divorce and used a different numerator in that calculation, as the appellant seems to be implying that they want to do, that the former wife's interest in that dental practice would have been significantly higher than it was. But again, as we indicate in our brief, there's no practical component to what the appellant seeks before this court. We listed a side-by-side comparison in our brief as to what the former husband appellant received previously compared to now. There's not a single asset as you look at it, and not a single debt as you look at it that is not divided equally. We submit to the court that that equal division is the best the appellant could ever do in court under the circumstances. Having no pleading pending before the court, even if a new trial were granted, which we're arguing would be improper, that there could be no day in court that would award him anything better than what he's been given right now. And therefore,
How did the judge, excuse me, how did the judge divide the marital home? You've indicated 50-50, but when I look at the equitable distribution chart that he attached to his order, it looks like he valued the home at $800,000 and then distributed $519 to the wife and $280 to the husband.
in all candor, when that was argued by counsel, it wasn't in any of the briefing arguments, but I did look at it and I'm kind of confused by it myself. What he ordered,
I understand the bottom line ends up at 50-50 on the total thing, but as far as that one asset goes, it doesn't look like it's 50-50.
It doesn't, but the property was sold pursuant to Judge Nichols' order, and it was divided 50-50, so this line item is, I wasn't familiar with why the judge put that in there. In effect, and I don't think there's any dispute about this, the property was sold and the property was divided equally, with the exception of the husband being a resident there at the property throughout the whole term of the proceedings. The wife moved into a $1,250 rental. He stayed on the riverfront, and the mortgage, taxes, everything equated to about $3,000. And Judge Nichols found that in light of circumstances and residing on a river on an acre of property, that was consistent with what a rental would be for him, that he shouldn't get credit for the mortgage payments made on that property. The wife did not get $519,162, as the equitable distribution sheet indicates. She got half of the proceeds of the sale. And in light of market conditions and the ongoing litigation, the sale of that property was much less than $800,000. It didn't sell for $800,000. It sold for about $630,000, I think, as I recall. And there was a mortgage of about $290,000 on it still. It appears on the sheet to be an unequal distribution, but the substance of the order itself required the parties to sell the property and divide the proceeds equally. And with regard to that asset and all the other assets, all the IRA accounts, the bank accounts, everything was divided equally as well. So, in light of the fact the appellant has not submitted to the court any very specific proffer as to what testimony or evidence may be presented to the court to result in an equitable distribution that is different than 50-50. I feel that the court is unable to make any determination as to how the appellant has been harmed by a decision if the court finds that there was any error at all. The court in the original proceedings does find, as Judge DuPont also reviewed it, that there was competent substantial evidence as to the valuation of the dental practice specifically. When we cite to the court in the final judgment itself, goes through in great detail exactly the evidence presented to the court as regard to the dental practice, the stipulation of the parties and consent of the parties to the expert, Roger Barong, who testified at those proceedings. And there was no contradictory testimony presented by any other expert.
Well, that only becomes relevant if we feel like it's appropriate to go back and revisit those issues.
Yes.
If we accept your argument that the trial court needed to look at 3 specific items and then only adjust the scheme if that caused something to get out of kilter,
Yes.
then the value of the dental practice is really irrelevant, isn't it?
Correct, and that's our position. I'm addressing it to the extent the court feels that there was any error committed by the judge in reviewing what they're calling a cold record.
And I think the issue in this case is really going to be whether or not the judge followed the mandate or didn't follow the mandate. If we think he followed the mandate, that's the end of it. And if we think he should have gone back and taken a more global view of things, then those issues would become relevant in round 3.
Sure, and unfortunately, the implications of the situation we're in, obviously, judges roll over somewhat quickly, change divisions, retire, that type of thing pretty commonly. And to allow in every circumstance where there's any type of modification to an equitable distribution plan with a rollover of that kind would create a situation where relitigation and retrial of issues that took a long time to litigate in the first instance would be required. And in this particular instance, having litigated 10 issues on appeal, 7 of which were affirmed, would result in folding over on to issues that have already been affirmed on appeal in the first instance and allowing a second bite at the apple for appellant on the same exact issues.
Well, I think we understand your argument.
Okay, very good. I appreciate the court's time this morning. Thank you.
Thank you.
May it please the court, I'd like to refer the court to the Smith v. Silberman decision, which is a decision from the 3rd DCA that we cite in our briefs. In that case, again, just like the Dash case, it was a decision after remand from an appellate opinion. And in that case, the mandate had directed the trial judge to consider evidence that should have been admitted. And so, on remand, there was a successor judge, and the successor judge only allowed the widow, in that case, to testify to that one specific item of evidence, but instead, and relied on the original transcript and the original proceedings as to the balance of that evidence related to that one asset. And the 3rd DCA reversed in that instance and stated that the general rule is a successor judge may not weigh and compare evidence heard before a prior judge. Absent a stipulation, a successor judge who does not hear all the evidence may not enter a judgment. Here, in this case, like the one here, the parties made no stipulations as to the evidence, and so the successor judge was required to hear all the evidence on the gift issue, that particular issue in dispute, for himself. The court goes on to explain that the prior directions and mandate of the court were directed to the original trial judge, but once the successor judge became responsible for the completion of the case, it required he not only hear and evaluate the surviving wife's testimony, which was a testimony that had been excluded, but he necessarily had to hear and evaluate all of the testimony directed to the issue of the gift in order to perform the quintessence of the function of a trier of fact in assessing not only the credibility of the testimony, but the weight which it was accorded. And so the successor judge's failure to hear the proffered evidence was reversible error. And again, the reason behind this rule is just the same as if this court attempts to reweigh evidence on appeal. In the Bradford case, that case, again, was a case that holds that a successor judge can't render a verdict without a trial de novo unless there's a stipulation of the parties. And again, it's not enough to just go back and look to what the original trial judge may have heard. And in the Bradford case, the court explained that no one would contend that the permanent absence of a juror after having heard the evidence and before a verdict is rendered would not be ground for a mistrial. So appellate courts, this court relies on a trial judge's findings of facts and credibility, but here, weighing of credibility. But this successor judge never heard the evidence, never viewed the witnesses firsthand, and it cannot go back and attempt to fulfill the requirements of the mandate without hearing at least some evidence related to what the scope of this court's mandate was. The former wife...
Was there ever any request to have Judge Nichols come back and hear this case over again?
No, Your Honor, but there's been no case law cited to require us to ask the original trial judge to come back. The former wife could have asked for the original trial judge to come back, and we did object at every opportunity to the successor judge hearing this case, at least without giving us an opportunity to introduce new evidence at every turn. The former wife, excuse me, now criticizes our efforts and argues that we haven't shown harmful error, and that we don't specifically identify what changes there would have been. But the fact is, it's the former wife who objected to our attempt to even submit a written proffer, who objected to our attempts to introduce new evidence and to require the successor judge to conduct a new trial. And so she should not be now heard to complain that we're not specific enough. Again, this court's mandate required the successor judge to revisit the entire scheme, and we ask that this court reverse that final order on appellate remand.
Thank you so much, ma'am.
Thank you.
All right, that will conclude our docket for this morning.